Hey there, I'm the MadCatster. Am I glad to see you here? Well, Blair, the Illuminati, has finally responded to Oz Media's motion to dismiss, and as you probably would expect by now, based on what we've seen, I think it's a hot mess, and I think it's really desperate and grasping at straws. We're gonna rip it apart. You know me, I've got the deets and all the receipts, so buckle up and let's go. So welcome you guys. Sybil is upstairs sleeping, but Cedric, as usual lately, is here with me, and Gilles, my three-legged cat at my feet. In my last video, we talked about Blair the Illuminati's response to Felix the Kit Kat's motion to dismiss. Well, now she's finally responded to Oz Media's motion to dismiss her Second Amended Complaint. And I think you're going to see how desperate this particular response is based on the way it's written and put together. We're going to dispel, debunk, and destroy some of the arguments that they've made and some of the points that they've tried to put across in this. I think her attorney, in my opinion, it seems like maybe he has a creative writing certificate because he seems to like to tell stories. We're going to start with the introduction, which is kind of a little novella in itself, and you'll see what I mean in 1 second. I'm sure you've all heard of data brokers where companies like take all your personal information and sell it to various people, from spammers to scammers to who knows who. So I searched myself and I was shocked at how many of these data broker companies exist. They get your full name, your address history, your court records, your phone numbers, your family members, and all of this information they make available to whoever pays for it. That's why I've been using Aura, the sponsor of today's video, and I would like to thank Aura so much for sponsoring this video. And I have been trying it out for the past month. I had looked, when they approached me, I looked them up, and Forbes magazine gives them an excellent rating, and I've been using it for the past month. But I'm really impressed with the wide variety of things that it does, and also they have a really great app that you can use as well. And one of the features of Aura is they will show you which data brokers are selling your information, but you can have them have you opted out of these services, and Aura takes care of all of it. I tried it out. It's really great. It's so easy. Information not only reduces the amount of spam that I'll get, but it also protects me from hackers who want this sensitive information. I feel really confident now that Aura has taken care of that for me. I don't know if you saw, but recently AT&T revealed that like the information of over 73 million people they had in their databases got released on the dark web. I mean, how frightening is that? AT&T recommended that people who might have been affected, that they use stronger passwords, they monitor account activity, and that they put either a freeze on their credit reports or fraud alerts with the credit bureaus. Well, what's really awesome, again, is Aura takes care of that for you. You don't have to deal with different apps and different websites in order to accomplish that. My information had been compromised from AT&T. I know I don't have to worry because Aura is going to keep me safe and take care of it. I value my privacy. I'm sure you do too. I feel secure with Aura, and I want you to feel secure with Aura too. They will give you a 2-week free trial. You can check out Aura and see how great it is. You go to aura.com/MadCatster. I'm also going to put the link down below in the description that you can click. You should check them out and use that link. It's on the screen here and it's down in the description. And I know that you'll be as happy as I am with Aura. So you see here is, the cover sheet. It's Pyramid Entertainment and Blair's response to, and this time it's focusing on Oz Media. It's plaintiff's response to Oz's motion to dismiss her Second Amended Complaint with certificate of conferral. And it just says, that through the undersigned counsel, they respond to defendant's motion to dismiss as follows. An introduction. Here's where the creative writing part, I think, comes in my opinion. This case exists because plaintiff began dating someone new, and her ex-boyfriend, defendant Oz, did not like it. Instead of respect her choices, defendant began a media revenge campaign against her by publishing false and harmful statements about her and her once lucrative business. Given the intensity of defendant's lashing out, one might imagine that plaintiff had flaunted her new relationship or done anything that would have prompted a reasonable person to act the way the defendant did. But she did no such thing. Indeed, her new relationship was not public. Defendant learned of the relationship only when he accessed plaintiff's personal computer without her permission and snooped through her private messages. Now, that's all conjecture because they've made this argument without providing so far any evidence to back it up. So this is a work of fiction to me. First of all, he didn't lash out at her or seek revenge because of her new relationship, which probably isn't even in existence anymore. Rather than seek revenge for her new relationship, given all the grief she's given him, I certainly would be happy to see the back of her, and I would have changed the locks and bolted the door when she walked out. But he's never mentioned, Oz has never mentioned her new relationship. Not at all, not once. Okay, she made an allusion to that in her, remember now, they like to play a little game of sleight of hand here where they're trying to make you think that this all started because Oz was just upset and jealous and wanted to get revenge on Blair, when in fact, this all started because Blair started it by putting out, first by attacking Legal Eagle, and then by putting up an apology video, which went on to encompass these attacks on all of these people that she was once involved with in business and friendship. The videos that followed after were all responses to stuff she put out there. She started it. It's her, she's the origination for all of this stuff. If she had just kept her mouth shut and done nothing, none of this would be happening right now, most likely. It says, to be sure, not all relationships end well. They don't. Even the best endings can cause strife. If a former romantic partner moves on and begins another relationship, it goes without saying, however, that defendant's discomfort at plaintiff's new relationship did not authorize him to publish false and harmful personal attacks against plaintiffs. Again, this is all conjecture. This is their theory, mind you, of the case. This is their theory. They're thinking that this is what's happened. They're ascribing this conduct to him, to Oz, without any evidence whatsoever. Okay? It's a work of fiction. They're pulling this out of their ass and putting it out there. Okay? Let's take a look now what they argue. And it's, you know, it doesn't get any better, I promise you, but stick with me. Let's start with the argument, okay? And again, there's parts I'm going to skip, like some of the case law I'm just going to skip because we don't need to dissect that. We just kind of want to get the broad picture here. The Second Amended Complaint was filed with the court's leave. Okay, I think the best place to start, let's take a look at what the court's order actually said about this Second Amended Complaint that she submitted. Okay, so here's the court's actual order for submitting the amended complaint. It says the motion proposed order attached hereto, action taken. Before the court is defendant Oz's motion to dismiss. I've reviewed the motion, the response, and the reply, and I am familiar with the case file and with applicable law. I also note the defendant has more recently filed his own motion to dismiss. It appears to the court that the statements alleged to have been made by the defendants that the plaintiffs contend are defamatory have not been pled with sufficient specificity for the court to be able to review them and determine whether or not they are defamatory. Wherefore, it is ordered within 14 days, plaintiff may file a second amended complaint. All alleged defamatory statements by all defendants shall be set out verbatim, and the media containing these statements, that is, Twitter, threads, videos, and the like, shall be disclosed to the defendants. If the complaint is not so amended, the court will rule on the pending motions to dismiss. If the complaint is amended as set forth herein, that will moot the pending motions to dismiss, and they may, if they wish, file motions to dismiss the second amended complaint. Okay, so basically what the court has said is she has alleged, or she did in her original complaint, that these people, the defendants, made defamatory statements against her. But she didn't provide any specifics. She didn't quote what they said that she claimed was defamatory. She just made vague assertions. So basically what the court said was, I'm going to give you the chance to fix your complaint and submit a second amended complaint that does these following things. Sets out the alleged defamatory statements verbatim, and on top of that, provides the media that they refer to. She didn't do what the court ordered, and we'll get to that in a second. So that's what the court said. Now let's see how Blair and her creative team have chosen to spin and interpret the court's order. So here is now the argument that they're making. The second amended complaint was filed with leave of court. Okay, so yes, as we saw, the court did tell them that they could file a second amended complaint in order to clarify what they had alleged because there wasn't enough specificity. The motion contends, that's Oz's motion, that the Second Amended Complaint did not set out the defamatory statements verbatim. This is false. The amended complaint quotes the statements at paragraphs 76 to 78 and 83 and provides a hyperlink and timestamps for the video where the statements were published. Now, I don't recall that they did set out everything verbatim. I will have to take a look back at that. It says the motion next argues that the Second Amended Complaint Computer Fraud and Abuse Act claim. So now when she submitted the Second Amended Complaint, they added in new stuff. They added in account for computer fraud. Okay. And what Oz's team was saying was, you can't do that because the court ordered you to clarify your complaint. They didn't order you to expand your complaint. Okay. Seems taking it with a sort of a nuance, and this is how they're trying to fudge it. They're saying that the court's order stated plaintiff may file a second amended complaint. Plaintiffs did exactly that. So they're trying to brush it off by saying, well, this is a second amended complaint, and we happen to put this extra stuff into it now, but the court said we could file a second amended complaint. But that's not really what the court said, as we just read. If you take it in context, what the court was saying, in my opinion, you didn't allege enough specificity about what you say is defamatory. You need to go back now and do that, and then submit a second amended complaint that has that extra stuff in it. They didn't say go and amend your complaint and add counts if you feel like it. It's not what this was about. This was about just being specific. The court's order identified required elements of the amended complaint, but no language restricted amendment to those required elements. Technically, that's true, because that one sentence does say that they shall submit a second amended complaint. However, again, they're taking it out of context. I don't believe, in my opinion, that that's what the court meant. They didn't mean go off now and just rewrite the whole thing and start from scratch. They meant fix it. Fix what you've already given us and expand. Also not clear how defendant would be prejudiced by the inclusion of the claim, given that discovery has not yet begun. So now the second part of it is, well, okay, maybe we did fudge it. They're saying sort of backhandedly, but this doesn't prejudice him because discovery hasn't started yet. Okay, but they're missing the point. The point is, I don't believe this is what the court meant for them to do. I sure hope the court strikes this part of their amended complaint, because I think it's irrelevant and it's now going beyond the scope, I think, of what the court intended. Plaintiffs therefore complied with the order by filing a second amended complaint that included the required elements. Moreover, plaintiffs note the defendant did not otherwise challenge the claim about the computer fraud. So what he's saying is, without arguing against them, because I don't think it's necessary either, it doesn't belong in there, Judge. We want it taken out because we're not going to address it because it shouldn't even be there. The motion also contends that the defamatory statements in claims 3 and 4 are not actionable because they were published after the initial complaint in this action was filed. This too fails because the court directed plaintiffs to file a second amended complaint, specifically requesting plaintiffs to identify all defamatory statements that you had already alleged in your original complaint, moron. Not go off now and try to find new stuff to put in. Again, it's like they're exceeding the scope of what the court intended, in my opinion. And so I sure hope the court puts them in line. I really want to see the court just dismiss all of this nonsense. It's just all bullshit, in my opinion. SAC Second Amendment complaint properly stated a breach of contract claim against defendant. A complaint survives a Rule 12b-5 motion to dismiss when it pleads sufficient facts that, taken as true in light most favorable to the plaintiff, state a claim for relief that is plausible on its face. And again, we've talked about this now several times. The court is going to always try to give leeway to the non-moving party because they don't want to just throw out the whole case if there's any possibility that some of these claims might be true or that there's facts that need to be argued at trial and evidence to be submitted. And that's true, okay? But it doesn't mean that you never dismiss a claim that's in its face or through what's been presented in the complaint and in responses is clearly without merit, okay? Oz's motion argues that the Second Amended Complaint does not state a breach of contract claim because it fails to identify any information that defendant wrongfully disclosed. This assertion is not correct. The complaint identified information subject to defendant's confidentiality agreement in a string of references in the Second Amended Complaint. Of those paragraphs, paragraph 41 identified Defendant Oz's public social media thread, which included the following statements. Anything Blair... Okay, first I'm going to read this and then we're going to talk about how absurd this is. Anything Blair needed to say went through me first, essentially act as a spokesperson. I always acted as her talking piece, from yelling at one topic to berating Click and other things I did in service of Blair. These posts revealed... Okay, this is their argument of why those two little things are somehow a breach of his confidentiality agreement, okay? You tell me if this sounds like it to you. These posts revealed internal business structure and practice. Quoting from the confidentiality agreement. Information and data not generally known outside the company concerning Pyramid or its business, including but not limited to all other concepts or ideas involving or reasonably related to the business of Pyramid. So they're trying to say, by Oz saying that he was her spokesperson or that he had to keep people in line, is somehow revealing confidential and highly classified information about how Pyramid works, because that's going to enable her competitors to steal her trade secrets now and go off and create a better channel than hers, which, well, at this point, that's not difficult to do. But what he's saying is so vague and is related merely to his job responsibilities that he's basically summing up in, I think, a very vague manner. He's not including a whole lot of specifics. That is not what this confidentiality agreement is meant to protect. Those aren't business structure and practice. You know, you're not talking about the secret formula or how they manufacture something that they don't want their competitors to find out and copy them on, okay? No one wants to copy her management style, I guarantee you. So I call BS on that part of this. As for the confidentiality agreement, the complaint referenced the document and quoted the actionable provision of the contract. Okay, so you quoted provisions that are inapplicable, in my opinion, to the current situation. And inapplicable to what you're alleging is breaking that agreement. The Anti-SLAPP statute. Now, we talked about this before, and in Janet, the mortician, that stuff, this has been brought up too. Anti-SLAPP, what it is it's strategic lawsuits against public participation, meaning that, in a nutshell, without getting too involved in the definition again, it's basically someone's suing you because what they're hoping is going to happen. You're going to capitulate and you're going to do what they want you to do because they're suing you and they're hoping that you don't have the resources to fight them. And so the real underlying purpose of the lawsuit, rather than what the claims are, is to stop you in your tracks and shut you up and get you to retract or do whatever it is that they want you to do. So what Oz was saying was, this lawsuit against him, it's basically a SLAPP lawsuit, okay? And that he's arguing the court should throw it out on that basis. Now let's hear how they try to counter that argument. And has filed this motion under the Colorado Anti-SLAPP statute. We talked about this in one of the other videos, but because the Colorado law doesn't have a whole lot of history to it yet, because it resembles California's Anti-SLAPP statute, oftentimes the courts look for guidance to how California has interpreted and how they're dealing with this law in their courts. And it's not, like I said, it's not controlling, I've said before, which means they don't have to follow what California does. But they're looking to it as to get an idea of how the courts are interpreting the language of these statutes. And then they say that the appropriate two-step process in determining whether it is a SLAPP lawsuit is the court must determine whether the defendant has made a threshold showing that the plaintiff's claims fall within the scope of the statute. Second, if the defendant makes that threshold, the burden shifts to the plaintiff to establish a reasonable likelihood of prevailing on the claim. If the plaintiff fails to satisfy this burden at step 2, then the court must grant the special motion to dismiss. And then they're going to talk about why they think Oz's argument fails. Step 1, the Anti-SLAPP statute does not apply to plaintiff's claims. So they're saying that Blair's claims in her lawsuit aren't violating the Anti-SLAPP law. At step 1, a defendant bears the burden to prove that the Anti-SLAPP statute applies to the plaintiff's claims. The statute lists 4 qualifying kinds of speech to which it applies. Defendant argues that 2 apply here, and the 2 that they say are any written or oral statement or writing made in a place open to the public, or a public forum in connection with an issue of public interest, or any other conduct or communication in furtherance of the exercise of the constitutional right of petition or the constitutional right of free speech in connection with a public issue or an issue of public interest. And that's Oz was saying that the statements that he made fall into one of those two categories. Then they say plaintiffs concede that defendant Oz's statements set out in the third and fourth claims for relief were made in a public forum, but not, in which I'm presuming they mean the YouTube video. Not every statement made in a public forum concerns the public interest. Not every website, and now they're quoting a case here. Not every website posting involves a public issue or an issue of public interest. To carry his burden to prove that the anti-SLAPP statute applies, defendant must prove that the statements not only implicate a public interest, but also contribute to the public debate. Now, of course, there's going to be argument on both sides about why or why not those statements fall into those categories. But she is saying that the statements do not implicate a public interest. At step one, the court evaluates the statements from the vantage point of a reasonable objective observer to determine whether the challenged statements implicate a public interest. For this determination, courts, and now they're citing to California law, which, remember I said, it's not controlling. The courts don't have to follow the rulings from California, but they're using them as guidance. For this determination, courts consider whether the statements concern political or social issues, public officials, people or businesses that had been the subject of news articles, a large number of persons, or a topic of widespread public interest. Now, I think it can be fairly argued that this whole situation on both sides is now, thanks to Blair, a matter of public interest. Because she's the one who started by putting it out there to millions of YouTube followers. And then that generated responses. And so this whole thing is taking place, I think, in the public eye. And they are all, I would argue, reasonably, even if minor public figures, they're certainly public personalities. And so, in my opinion, I think that Oz has met that burden. Generally, a matter is of public concern whenever it embraces an issue about which information is needed or is appropriate. That's very vague. Or when the public may reasonably be expected to have a legitimate interest in what is being published. Now, that's a very sort of vague and subjective statement, because what constitutes what the public may reasonably be expected to have a legitimate interest in? How do you determine that? I think that when you've got an issue that is attracting millions of views like this is, that the public does appear to have a legitimate interest. And it's not like the public has gone digging for this information. It's been handed to them and spoon-fed to them on the internet by the parties involved. So I think the public does have a legitimate interest, in my opinion. His burden, defendant argues that his speech concerns the public interest because plaintiffs produce video content on YouTube. Well, I think it's a little bit more than that. It's not just that they produce video content on YouTube. It's that they're major YouTube personalities, okay? They're not me, okay? Who's got his smaller but well-loved audience. They've got a whole lot more people looking at their stuff than I do. I think that it's more than that they just produce videos. I produce videos. Blair has a big presence on YouTube, or did. And so I think it's more than her just putting video content on YouTube. It's the fact that she is or was the entity that she is. Except for the subject of the statements, defendant's public interest argument makes no reference to the content of the statements, which concern private disputes without reference to social or political matters of interest in his public interest argument. It doesn't have to be necessarily a big social issue or political issue to be of public interest. We all know that. We all know what we're interested in. It's not all about politics and social issues. Not every statement about a celebrity, however, implicates the public interest. Well, yeah, of course. Not every statement, but there are statements that do. Indeed, even a person or entity mentioned in national publications. Okay, mentioned in national publications. Okay, not talked about in depth or in content that they themselves put into publications, is not necessarily in the public eye. Okay, yeah, but I don't see that applies in this particular situation. The advantage of an objective, reasonable observer, it is difficult to see how a private revenge. Now, see, here we go again with the hyperbole. They are continuing to call this a private revenge campaign. First of all, I've seen no evidence that this was a revenge campaign. Everything that I've seen, and that probably you have seen, is people responding to the shit that Blair threw out there at them, trying to muddy their names, in my opinion, trying to turn them into pariahs and make herself look like goody two-shoes victim. She started it. I'll say it again. She started it. She started it. It's not a private revenge campaign. Show me the evidence, please. Do not just give me this bullshit, empty hyperbole that you continue to spin from your fictional web, okay? It's not a revenge campaign unless you show me the evidence of where it's a revenge campaign. Just because you don't like what he said, and he's saying it in response to the crap you put out there, it's not revenge. It's a response to try to keep his reputation intact from the shit you put out there. Bennett has not carried his burden to show that speech implicates a public interest. I disagree with you. The statements do not go beyond the parochial particulars of the given parties. They're now saying, even assuming the statements implicate a public interest, defendant would need to establish a nexus between the challenge statements and the asserted issue of public interest. Well, the nexus is the statements are directly related to the issue that's been put out there in the public by the parties, starting with Blair, that's made this an issue of public interest. It's all tied together. I see the nexus perfectly. It's like black and white to me. Agile thinkers armed with a fondness for abstraction. Oh, talk about fondness for abstraction. And a knowledge of popular culture could brainstorm a link between the challenge statements and an issue of public concern, however attenuated. Courts therefore require some degree of closeness between the challenge statements and the asserted public interests that goes beyond the parochial particulars of the given parties. In determining whether such a nexus exists, courts look to content, form, and context of the statements in conjunction with the speaker's motivation. Guess what they're going to imply here? Statements primarily made from a private desire to punish or exact revenge. Now, I think you could turn the tables and say, Blair, the stuff that she put out initially that started all this was meant to exact revenge and punish people that she was displeased with or she perceived as becoming her enemies. And, this was her way of dealing with her enemies. It blew up in her face. Made from a private desire to punish or exact revenge lacked the requisite nexus with public interest. And then they give this case here about a veterinary clinic, which is totally not on point at all, even though they think it is. For instance, the defendants in Tender Care posted scathing reviews of a veterinarian's office to a public website. The Tender Care court acknowledged that public reviews of the veterinary clinic could feasibly implicate animal welfare, which is a public interest issue, of course. However, the statements did not contribute to any broader public discussion about pet health or connect to any broader issue of public concern. Instead, the posts, by and large, attacked Tender Care and its staff and urged others to join her crusade against Tender Care to punish it for what she thought was an inadequate response to her criticism. Ultimately, the court concluded that the anti-SLAPP statute did not apply because the defendants had published the statements to exact revenge by putting the veterinarian's office out of business, which lacked any degree of closeness to the asserted interest of animal welfare. Here's a woman in this lawsuit they're citing who was angry with the veterinary clinic because they didn't do or respond to her criticism the way she wanted. So she then went and made up fake reviews. That's, like going on Yelp and trying to attack a business because of something they did you don't like. That's not the case here. I'll say it again. The videos that she's attacking in her lawsuit were in response to negative crap she put out there about these people. That's what it is. They didn't say, oh, she said something we don't like, so we're going to do something unrelated to punish her. No, it's completely related because they directly responded to the crap that she was spewing, and they tried to set the record straight. There's a big difference between that and just doing some random thing like give negative reviews to try to hurt a business, okay? They weren't attacking her business. They were attacking what came out of her mouth directly. Like the disgruntled clients in Tender Care, Defendant also published his statements to punish plaintiff for dating someone new. You know, here was Blair sitting there minding her own business, and here comes Big Bad Oz and said, I don't like the fact you're dating somebody else, so I'm going to say all this stuff about you. Never has a relationship or her new relationship been mentioned, even though they're trying to impute that on him. He mainly defended himself. And as he had said, he didn't even reveal everything involved in the functional relationship they had. He was trying to be conservative and just address the nonsense she was talking about. So this has nothing to do with her dating someone new. It's about her opening her mouth and trying to impinge the reputations of other people, and doing it so publicly because she wanted the public to turn against them and to be on her side. That's what it boils down to. It's not him getting revenge. I'll say it again. It's her trying to get revenge. And it blew up in her face. And so now, to try to save whatever's left of the face that she's got in her reputation, she's filing this lawsuit to try to prove that she's in the right and she's the victim. So they're saying that because of that, anti-SLAPP doesn't apply. I disagree. I don't think that's going to fly. Step 2, plaintiffs have a reasonable likelihood of success on their claims. If the anti-SLAPP statute were to apply, the court would proceed to Step 2 and review the pleadings, affidavits, and evidence submitted by both sides to determine whether the plaintiff has met its burden. At this stage, the court must take the plaintiff's evidence as true and evaluate the defendant's showing only to determine if it defeats plaintiff's claims as a matter of law. The court may not weigh evidence or resolve conflicting factual claims. The claims are both defamation claims, including the following elements. Okay, that it's a defamatory statement concerning another published to a third party with fault amounting to at least negligence on the part of the publisher, meaning they negligently didn't bother to determine whether it was true. And either actionability of the statement, irrespective of special damages, or the existence of special damages to the plaintiff caused by the publication. Claim 3, the defendant falsely accuses plaintiff of extortion in public video. Now, we've talked about this before, and we're going to quickly revisit it here. They're saying this. Claim 3 is likely to succeed. Plaintiffs presented evidence. They keep calling things evidence that I don't think are evidence. That the defendant published a statement falsely accusing plaintiff of embezzlement by using company money for a personal purpose. He did not accuse her of embezzlement. He was repeating what he claims she told him. Mr. Gilles has come to join us. Hello, Mr. Gilles. So they're saying it's not embezzlement because the plaintiff is the sole owner of the company from which she executed owner's draws, meaning that because it's an LLC and she's a single member, that she's taking money from the company, that she's basically paying herself. And, you know, I mean, within LLC structures, that's something you can legally do. She did that to make the loan to Oz, or allegedly make loans to Oz. An entirely legal procedure. Now, again, what I'm going to emphasize again is he did not accuse her of embezzlement. He said she told him he had to sign documents so that she wouldn't get into trouble. Now, he's not a business law or an accounting expert. He doesn't know what is right or wrong with what she's doing with her LLC. He's claiming she's telling him this stuff, and he's relating what she allegedly told him. So he's not accusing her. He's saying she said this is what would happen if he didn't sign the documents. Plaintiffs alleged, and the evidence supports, the defendant published the statement with at least negligent disregard for its truth. The statement, a false allegation of a crime, is actionable irrespective of special damages. Again, he didn't accuse her of a crime. He said she told him that she could possibly get in trouble if he didn't do a thing for her. How could he be negligently disregarding the truth if all he's doing is relaying what she told him? He's not making this independent statement. He's repeating something that was told him. So I don't think that's negligent at all. The motion does not dispute falsity. It instead argues that plaintiffs are public figures and that statements therefore concerned a matter of public interest and triggered the elevated burdens to prove by clear and convincing evidence that defendant made the statement with reckless disregard for the truth as a public figure must. Plaintiffs disagree that this standard applies. For starters, the statement is not closely related to a matter of public interest as argued above, nor are the plaintiffs public figures. Public figures include, for example, candidates for elective public office. That's one category. The motion does not provide argument on this point except to assert that being a YouTube personality makes someone a public figure, apparently the same way running for elective public office would make that person a public figure. That's not really true. It's not apples to apples. Just being on YouTube does not make you a public figure. I would agree with that. But when you've got millions of followers and you're on YouTube and millions of people are watching what you're putting out there, I would then, there's a reason why they call them influencers. I would then argue that that makes her a public figure because she's of a size and recognizability enough that that's what she is, a public figure. But media attention alone does not make one a public figure, nor are businesses per se public figures. Without case law or further analysis from the motion contending otherwise, the public figure question is better addressed under the limited purpose public figure framework. Under that framework, a person becomes a public figure to the extent that they have placed themselves forefront of a public controversy in order to influence the resolution of the issues involved. Courts must examine the nature and extent of an individual's participation in the particular controversy giving rise to the defamation and determine whether the defamation falls within the limited scope. Here, plaintiffs alleged and presented evidence. They gave their side of the facts. They didn't present anything that you could objectively look at and determine whether or not this is the case. And the evidence that defendant hauled them into public controversy about a private dispute to elicit sympathy from others and punish plaintiff for her choice to date someone else. Again, they keep trying to hammer that home, like somehow it's going to make it true, okay? It's completely baseless, in my opinion. Defendant has failed to present evidence that proves plaintiffs are public figures within the scope of defendant's false accusation that plaintiff engaged in embezzlement. He did not accuse her of that, as we said. Consequently, the elevated standard of proof does not apply. I disagree, okay? And it wasn't for him to get sympathy. He wanted to punish her for her dating choice. Who the hell cares who she dates? If you'd kept your mouth shut, none of this would be happening. And if the elevated standard applied, the allegations and statements are reasonably interpreted as being made with reckless disregard for the falsity of the statement. Defendant made the statement unsure about whether the word embezzlement was used, but deployed the word anyways. And he made it clear that he wasn't sure that's what the word she had used, but he made it clear that she had told him these things. Defendant's desire to exact revenge provided the motivation to lie. Now they're calling him an outright liar. Defendant presents no evidence or argument contesting the falsity of the statement or of his state of mind. He therefore does not defeat plaintiff's claim as a matter of law. Plaintiffs are likely to succeed on claim 3, defamation per se. No, they're not. I doubt it. Claim 4, defendant falsely accuses plaintiff of coercive financial dealings. Claim 4 also is likely to succeed, in your opinion. Plaintiffs presented evidence that the defendant published statements carrying the defamatory implication that plaintiff engaged in financial coercion. These statements were false, and defendant knew them to be false. For example, now here, again, we're going to try to insert new information that they didn't previously cite in order, in my opinion, not to clarify, but to throw more dirt at Oz. And try to make Oz look as bad as possible so that everybody thinks, poor Blair, she's a victim. For example, plaintiffs actually gave defendant financial support for his crypto mining project. Now, they've never mentioned crypto mining projects. This is so out of context and out of the blue that in my opinion, there's only one reason they're doing this. Again, it's to besmirch Oz a little bit more. By issuing personal loans to him so that he could purchase necessary computer hardware. See personal loans attached here to his Exhibits 3 and 4. Plaintiffs suffered damages from defendant's statements as proved by the loss of revenue in the 2 weeks following the publication of the statement as compared to the previous year. We're not even going to talk about that. Defendant contends that the Second Amended Complaint failed to explain by innuendo why the statements identified under the defamation per quad claim were in fact defamatory. But the complaint alleged the innuendo. The statements had the tendency to imply that Blair engaged in financial coercion, causing some form of indentured servitude. Now, what he was talking about was he was saying that the amount of money he was making working for her versus what he owed her in monthly payments basically left very little for him to live on or save or get ahead on. And they're saying that the argument fails. Defendant also challenges the specific damages pled by plaintiff at paragraph 88 of the complaint, but by providing a chart purporting to display viewership numbers over time. And they're going to dispute like the validity of the charts, and I don't think we need to really go over that. And they're just basically saying, oh, well, the charts both reveal and conceal information, and somehow, they're not accurate. Okay, that's basically what they're saying. So we don't need to go into depth on that. And so they're saying that consideration of the chart propounded by Oz would be inappropriate under the rule, even if this were a Rule 56 motion. Okay, they're saying that this is something that needs to be argued at trial, and they may have a point there, because you can't just take one set of charts as being, the correct ones. In the conclusion, wherefore plaintiffs respectfully request this court to enter its order denying the defendant's motion. And that's it. So he's now responded to him. Tell me down below what you think. Okay, so I can't predict how the court's going to rule, but in my opinion, after looking at all of this, I think that you're playing a little fast and loose with the context of the court's order and sort of trying to shoehorn in some new things to the Second Amended Complaint that weren't in the original complaint because they thought it would beef up their complaint. But in my opinion, I don't think that's what the court meant by the way I read the order. I don't think that in context, the court was intending for them to create new claims and add in allegations. Hopefully the court's going to grant Oz's motion to dismiss, and hopefully all of these parties will finally be free of this. Know what you think down below. I'd be happy to hear it. Cedric's still here. And someone had made a comment about how I keep going even though Cedric's like in my face. You got to understand, I get so used to them that sometimes I don't even notice that he's like right in my face, and I'll absentmindedly like maybe move him or put his tail down or whatever. And I'm not really thinking about it. It just happens because I'm so used to it. Some people to thank from Amazon, some more people. I've got more people to thank from Amazon, but I'm going to save some of them for the very next video, which I am putting together right now. Okay, so let's thank some people from Amazon. And again, if you don't hear your name, please don't panic. I've got other people to thank from Amazon, but I didn't want to throw them all into one lump. I'm going to put some of them in the next one. So if you don't hear your name in this one, it should be in the next video. So from Amakiaria, I hope I pronounced that right. Got some Blue Buffalo canned cat food. Thank you so much. The canned cat food is particularly appreciated along with the treats because of how much we go through. And then from Laura J. WK, one of the jingle balls that the cats love to push around the house. And we also got one of the nice round donut beds that the cats love. And I actually gave that one to Antoinette because somebody stole her bed. One of the bad kitties, I won't name, even though they already had their own bed. So I gave Antoinette a new bed. So thank you very much for that stuff. We really, really appreciate it. We also have from Jordan P. We have Blue Buffalo wet cat food again. Thank you. Thank you. And we got some catnip mice, which the cats love and which we do go through a lot of those because, as you can imagine, they don't last very long when they're getting tossed around the house. So then from Elizabeth P.S., we got jumbo stuffed crunchy cat treats. Thank you. Thank you very much for that. Okay, so those are some people that I needed to thank, and I have, again, several more. I also have a bunch more to thank in the next video, so if you didn't hear your name tonight, you'll hear it in the next one. I've also got some people to thank for the Buy Me a Coffee, which I've told you before is the only thing that's for me. All the other stuff's for the cats. I'd like to thank Amanda Tamain for buying me a coffee, Jay Henley for buying me a coffee, Oakty 2003 for buying me 5 coffees. Thank you so much. Ridley Kit for buying me a coffee. Lust Star for buying me a coffee. Thank you guys so much for the coffees. I'd also like to thank our Patreon patrons, of course, as always. Your support is so important to me and is so helpful to me in paying the cat's monthly vet bill, which I actually pay twice a month. So thank you so much for that. And to our channel members who also contribute towards that goal, I really appreciate that help, and your support means so much to us. Thank you for continuing to support us, and thank you to the people who have decided to come on board and support us. We really appreciate you. As I said, I've got another video. In the interim, as always, take care of yourselves, love one another, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.